Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I am your host. Today in the studio, we have Dayna Jones, a native of the Pacific Northwest. Dayna L. Jones has lived in San Antonio, Texas since 2004. In 2004, she moved to Texas to attend law school at St. Mary's University. Upon graduating from law school, Dayna was awarded the San Antonio Criminal Defense Lawyers Association Scholarship for her work and dedication to criminal defense. Dayna L. Jones has tried cases ranging from misdemeanors such as DWIs and assaults to felonies ranging from drug possession to sexual assaults to murders. A large portion of her practice is dedicated to post-conviction work such as appeals and writs of habeas corpus. She's argued appellate cases in the 4th Court of Appeals in San Antonio, the 5th Circuit Court of Appeals in Dallas, the 13th Court of Appeals in Corpus Christi, and in the Court of Criminal Appeals in Austin. Welcome, Dayna.
Thank you.
How are you today?
I'm doing pretty good. How are you?
Great.
Good.
I got to hear a little bit from you the other day. You came into class and talked to the students about writs of habeas corpus and appeals. You did a great job.
Thank you. That was a lot of fun.
Yeah, I bet. You do that often?
I do. I also teach a couple classes myself. So, yeah.
Where do you teach?
I teach at St. Mary's in their Masters of Criminal Jurisprudence program.
Very nice. So what exactly is a Masters of Criminal Jurisprudence?
It's their master degree in criminal law, basically. So they're master's students, it's through the law school. They're not law students yet. Some of them have ambition to go to law school, but they're getting their master's degree.
So you're a graduate professor.
Yes, I am.
Very nice. You know, we were having this conversation the other day. You were in the courtroom trying the case. You said when you were a baby attorney, and you said I was a baby judge.
I think you were, yeah.
Yeah? About how long ago was that? Do you remember?
It had to have been about 16 years ago, 15 years ago, somewhere in there.
Yeah. You got a lot out of it?
Yeah.
Very nice.
Yeah, I haven't tried cases in a long time. I've now shifted my practice to the post-conviction side, but it's been a while since I've actually been a trial lawyer.
I do remember you in court trying the case. I don't remember what the case was about. I remember it was with now former District Judge Lisa Jarrett. Y'all were trying it together. And the reason why I remember is because after you have a trial with someone, there's sort of like a kinship that develops as a result of that experience, right?
Yes.
You're kind of going through a process together. So I've been able to watch you grow as an attorney.
You have, yeah. You actually, the first time I ever met you, you were running for a judge. I was a very, very baby lawyer in jail court, and I had no idea what I was doing, and you helped me out. So I always appreciated that too.
That's nice to hear. Thank you for reminding me of that. Well, we are here because you do a lot of work related to writs of habeas corpus and appeals. Can you explain to our listeners what that means?
Sure. So let's say there's a trial. Right after the trial, that would be the appellate process. So you're really in the appeals process. They're very separate. So the appeals process is focused on what happened on the record in trial. Legal rulings that the judge made, objections that the defense attorneys made, arguments that were made, witness statements, everything that goes into the record, that's what we get to appeal. A writ comes, it can come after the appeal, or if there was, if it was a plea case, then it could just come right after the guilty plea. But a writ, I really look at it like a hybrid between a trial and an appeal, because we're doing a lot of the same things where an appeal is all just research and writing. We're doing a lot of that, researching the issues, but we're also reinvestigating what actually happened, kind of coming up with what. Did the lawyers forget to do something? Did they not interview certain witnesses? Was there a defense not presented at trial that could have been investigated? So really, you're kind of mixing those two things together to make a writ of habeas corpus.
I work in a trial court, and a district court is the highest trial level court in the state. A district court in the federal system is also the highest trial level court in that particular system. An appellate lawyer then works with a different type of process. In other words, a trial court is where you have witnesses, where you have juries, court reporters, and everything that people see on TV. An appeal in and of itself, and I'm talking about a direct appeal, that's something that does not have those things. That goes to a specific appellate court, whereas a writ, which we'll separate when we have our discussions, is more related to sometimes you need new evidence to make the record better, and you use that information then to do subsequently what looks like an appeal.
Yes, exactly. So when we file the appeal, that goes into the appellate court system. So different judges, like you said, there's in Texas, there's 14 different districts. San Antonio is represented by the Fourth Court of Appeals, and we get a panel of judges assigned to each appeal. Those are the intermediate court appellate courts. They have to hear appeals that come to them. After that, if if you're unsuccessful on your direct appeal, then you can take it up to the Court of Criminal Appeals, which is in Texas the highest court for criminal cases. The Supreme Court of Texas hears civil cases, where the Court of Criminal Appeals hears the criminal cases. So in the appellate so my briefing and all of that gets filed into the appellate court, and it doesn't have anything to do with the district court judges at all.
And most of the time, the trial court has no idea what you're doing on that level, unless an appellate court is either telling a trial court to do something like get new evidence to force a brief to be filed, or the case was remanded back to that court for another hearing or another trial or whatever the circumstance is.
Exactly, yes.
So let's sort of track how a case goes. Let's make up a fictional case. Let's say there's a murder trial. The murder trial is tried in the 379th District Court with some really good attorneys and a judge. Jury comes back with a guilty verdict. The judge then imposes sentence in accordance with what the jury instructs the judge to do. Let's say a person is sentenced to life. What happens then?
So let's say they come and hire me, and I would first contact trial counsel, because I probably didn't sit through the trial, to see, are there any issues for a motion for new trial? I usually like to get the law that the judge has given, the jury instructions, to see if the judge made any errors that I can see in the jury instructions, because that's always a good ground for a motion for new trial. If there are grounds, if I talk to trial counsel and they say, yes, I feel like the state did something that they shouldn't have done, or I didn't get a jury instruction that I had requested, then I would go and file a motion for new trial. Hopefully the judge would give me his ear and let me hear it. If not, then we can just go into the appellate process if he doesn't want to hear that motion. The appellate process, then I file a notice of appeal with the trial court still, and that gets by the clerks of the court walked over to the appellate court and gets filed in the appellate court, and then the process starts. Then I have to wait on the court reporter. I request the court reporter's record, the clerk's record, which is the clerk's record. The difference there is clerk's record is everything that was filed into the court. It's essentially the judge's kind of file of all the documents that got filed with the clerk's office. The reporter's record is everything that the court reporter was taking down. That then gets filed with the appellate court, and then my briefing deadlines start. As soon as all the files are filed with the appellate court, I have 30 days after that to file a brief. And then the state would have a chance to respond. The defense or the appellant, the defendant becomes the appellant in that situation. Then we would have another chance to respond as kind of a rebuttal brief. And then we wait for the court to either give us oral argument. If they do, then I get to go stand in front of a podium and a panel of 3 judges and argue the merits and the law of my brief. I love doing oral argument. And if the judges say, no, we don't want to hear oral argument, then they just do it on the briefs alone, and we wait for their opinion to come down.
After a jury trial, let's say the jury comes back and finds our fictitious defendant guilty, then you have, upon the sentence, 30 days from that day to file a motion for new trial and a notice of appeal.
Correct. So you can either do a motion, well, you can do both if you want, or you could just do the motion for new trial within those 30 days. If the motion for new trial, once it's filed, it extends it by another 45 days. So essentially 75 days from the date of sentencing, the judge has jurisdiction to rule on that motion for new trial. If he doesn't, then after that, he loses jurisdiction, and then the notice of appeal can be filed at that point. Or if you're not going to file a motion for new trial, you can just file a notice of appeal within that 30-day period.
So if an attorney then files a notice of appeal, then automatically that appeal will be heard by the intermediate court. If you live in San Antonio, that'd be the Fourth Court of Appeals, because everybody has a right to have that appeal heard at the onset.
Correct. If they were given permission to appeal, so with our fictitious defendant, he went through the whole trial process, he would get the right of appeal, yes.
What about individuals that plead? Let's say they enter into a plea bargain for guilty, they get a sentence, and for whatever reason, then they don't like that sentence, they want to refile or they want to file an appeal.
They would have to have permission from the court, and usually permission comes if there was like pretrial motions that were heard and ruled on by the judge that didn't go favorable to the defendant. They would have permission most likely to appeal those. Now, if they waived their right to appeal everything, then they wouldn't have that right. But if they did get some pretrial motions, then the judge could give permission in that circumstance.
All right, so you talked about a motion for new trial. Now, the purpose of a motion for new trial is to gather additional evidence, because once that case is before the appellate court and the direct appeal, you don't have that opportunity.
Correct. So yes, obviously we would love to get a motion for new trial granted, because that just restores the person to a new trial.
A new trial.
You get to start all over again. They're no longer convicted. They're no longer sentenced, and they get a new trial. But we really look at a motion for new trial as expanding the appellate record. So if there's something that happened in the court, but it didn't make it into the record, we would want to put in there. For example, let's say we got evidence or information that the jurors went and looked at something online that they weren't supposed to look at. They didn't follow the judge's order. That's not going to be anywhere in the record. But let's say a juror went and told, one of the defense attorneys after the fact, then we would want to put all of that into the record. So it's really things that aren't in the record or things that are in the record. There's certain, like I mentioned, if the judge gave, the wrong law or something like that, those are kinds of things that we could add to a motion for new trial. But really, yes, you're correct. We're trying to expand the appellate record.
So in general, something like juror misconduct or some sort of juror obtaining outside information that maybe influence their verdict.
Yes.
Right. Maybe later you find out that a juror talked to somebody who then gave them information that was in the newspaper, or maybe they looked something up. In one case, I heard of a situation where a juror was trying to figure out during the trial whether or not it was nightfall at the time of a crime being committed. And so then they were trying to figure out, was daylight saving time in effect on this particular date and this particular year? That's somebody who's going outside the scope of what the judge has told them they cannot do.
Yes. They went and did their own investigation, and that is not supposed to happen with jurors. All of the information that they have is what they hear in the courtroom. So if they did something like that and somehow, somebody found out about it, that would be something that we would want to put into a motion for new trial.
So then what you would do is you would call the juror in, you would serve them, subpoena them, whatever the situation is, have them come in, testify about what they did under oath. In doing that, you're making the record more complete to have something to present to the appellate courts.
Absolutely, yes.
And then also what I've seen is motion for new trials that are requesting an opportunity to show ineffective assistance of counsel.
Yes. So that is actually kind of a debatable issue. I have definitely raised ineffective on a motion for new trial, and there's a lot of case law that says the right time to do that is in the writ of habeas corpus. If you have your grounds together and you have, all the information that you need to raise a good, valid, ineffective claim, you can definitely put it into a motion for new trial as well. Not a good idea if you don't have a good, strong claim. Save it for the writ of habeas corpus.
You want to give us an example as to how something like that would work?
Sure. So one of the motion for new trial that I've won, client was told, asked, are you a resident? And he's like, yes, only Spanish speaker. And he was being offered 5 years deferred. So not going to prison, not a conviction on his record. And the lawyer told him, well, you'll get deported if you take this deferred. And he's like, well, I don't want to get deported, so I'll go to what's my options? The lawyer said, go to trial. He goes to trial and he gets 60 years in prison. Family comes to hire me, and I asked, is he a U.S. citizen? And they're like, yeah, he's a naturalized U.S. citizen. So when the lawyer had asked him if he was a resident, he meant he was a resident of Bexar County. He was actually a naturalized U.S. citizen. He is not facing deportation at all. He could have taken the 5 years deferred and avoided the trial, the 60 years in prison and everything. So I filed ineffective on that, and the judge did grant the motion, and I got him a new trial, and he got his probation.
So the lawyer gave the defendant inaccurate advice related to collateral consequences.
Yes.
And that's probably a big area that is ripe for appeal for somebody that does your kind of work.
Yes, there's some collateral consequences that the courts are like, those aren't big enough that, they're not going to really affect you. But if it goes to the heart of the reason that you're either accepting or not accepting the plea deal, then yes, that is a collateral consequence that can get you a new trial granted.
So there's a certain standard that applies when you're looking at something like that, right? Something related to would the decision making have changed? Would the end result of the trial has changed? What is that standard?
Strickland versus Washington is the standard for ineffective claims. It's a two-pronged standard. First is we have to show the burden is on us at that point too. We, as the defense, now have the burden to prove that a lawyer was deficient, their performance was deficient. And then the second prong was a lot of the times where we lose is that the defendant was prejudiced by the defense attorney's conduct. So the two prongs that we have to prove, it's difficult to do because there's a presumption that lawyers did everything right. So we also have to prove that and overcome a presumption that they were fine in what they did.
So without an opportunity to examine that lawyer in front of a court reporter to develop that record, that tends to be pretty hard to do because theoretically, a court could say anything that the defense attorney did at trial could be related to trial strategy, trying to, if I object at this particular point, I didn't want to distract the jury in this other way, or I could tell by looking at them they were being frustrated by what I was doing and I didn't want to further inflame that. There's a lot of different things that could have happened, but without a record, you would never know.
Exactly, yes.
You mentioned a bit ago that another area that's ripe for appeals is related to the law that the judge gives the jury. And you talked some about the charge. So the charge has all the instructions. And generally what happens is at the end of the presentation of all the evidence in a jury trial, the judge then will read the law through the charge of the court. And there is a lot of opportunity for a successful appeal based on what the judge puts in that particular charge.
Yeah. And that's where probably the stress comes down on the court a little bit, is that getting the right law in there to charge the jury. That is something that is discussed between, there's a charge conference where the state and the defense are arguing over the proposed jury charge that the court has presented. The defense is sometimes asking for certain defense instructions, like if there was a self-defense issue. And as the judge, you would have to make a decision on whether or not that applies to this particular case. So let's say you didn't give a self-defense instruction because you didn't think that the evidence raised it. That might be something that is now preserved for appeal because the defense requested it. It was overruled by the court, and it could be something that could be an issue on the appeal.
So let's say you got more evidence in a motion for new trial, and now you're getting ready to take care of the brief. What kind of work goes into something like that? I mean, for me, I look at some of these briefs and I see a lot of language is the same, generally, depending on the topic, depending on the issue, but a lot of it is novel. There's a lot of work that I imagine goes into researching, reviewing a record, and preparing for that brief. What is that like for you?
So it is a lot of research and writing, a lot. We have to read through the entire transcript, and sometimes on average, a day's worth of a transcript is like one volume. From trial, it's about 300 pages on average. Then I'm going through, let's say it's a 5-day trial. I'm looking at about 1,500 pages that I'm looking at reading just for this one particular case. And then you're trying to identify all the issues. Were there objections? Is this a valid objection that the defense was making? Did they preserve the error properly? And then I'm going to my research database, which I use Westlaw, and looking up the law, researching. We usually, the way that appeals end up working out is, here's a fact scenario that probably has never been seen before in another case, but we're trying to take laws the judges, the appellate courts have already ruled on a particular issue, and then apply it to the facts of my particular case. So that's the kind of the process. So a lot of being detailed oriented, reading through every word of the transcript, reading through a lot of case law to get to the arguments that I'm going to make in the brief.
What's interesting to me is you're looking at prior cases where the law has been written out and interpreted through whatever the facts were of that particular case. And so when you're looking at these records, you're seeing completely different issues, completely different facts. And sometimes those facts don't ever fit into what the prior case law discusses, right? So how do you then try to make those type of square pegs fit into those round holes?
Creative writing, really taking a lot of the language. I mean, there's sometimes some really good language just about the law, and then we can just kind of plug it into how it's going to apply and then make that analogy of how it should apply to my particular set of facts. Doing it that way, and sometimes every now and then you do get a case that is factually on point, and then you really can apply everything that the judges wrote about and said about those particular set of facts to your case as well.
Well, the way the law works, the way I've always read it, is courts are very conservative in how they change the law because it's a very slow process, issue by issue. one tiny little issue could totally create a different direction for the law to go based on that topic. And so, what is that like for you to sometimes find that needle in a haystack, that opportunity to create something new?
It's fun. It's sometimes, I mean, I like to think that I'm creating something new, whether the judges are going to actually agree with me or not. But it is fun to kind of expand your view of something and to think critically about, take these law from these judges and apply them to my facts and hopefully make a new argument that the judges are going to believe in and be able to side with me.
All right, Dayna. Now let's do a quick Q&A break. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome to the Q&A break. We have a question. In the jurors episode, they mentioned that you can volunteer to be on the grand jury. How can I do that? What do you think, Dayna?
From what I understand is that you can, when you select a grand jury, they can actually, I mean, if you have to be summoned down, right, to be on the panel, and then you can raise your hand and say, I will do it. And if you don't, then the judge can kind of rope you into or kind of told you to do it.
That's pretty much it. So the way grand jurors work, summons go out just like any other type of jury, completely at random. So they take information from a database from the Texas Department of Public Safety and from the voter registration folks. They throw all those names into the system. The system then will come up with whoever it is that is summoned to go in and serve on a grand jury that day. Now, when you come into the courthouse, generally in Bexar County, we have about 40 to 50 people that come in for a grand jury. The judge instructs them on what the proper qualifications are to be on a grand jury, then tells the individuals that if there is an exemption legally that could apply, that they could exercise it if they choose to get off. At that point, then it's up to the judge to figure out who the 16 people on that grand jury are going to be. Generally speaking, we have 12 grand jurors and 4 alternates. The alternates come in then if one of the prior grand jurors becomes incapacitated and cannot serve at that particular point in time.
I was just going to say, I had no idea about the whole process. I've never been a prosecutor or a part of the grand jury selection process. So,
well, the grand jury is part of the Fifth Amendment of the United States, which I'm sure you're very familiar with.
It is.
Being the defense attorney that you do. Anything else about grand juries that you find interesting?
Just as a defense attorney, they're very secret to us. We don't know when they're meeting. We don't know when our client's case normally is going to get presented to the grand jury for indictment. So we sometimes find out after the indictment that our client got indicted.
That's right. Upon their oath, grand jurors swear that they will never reveal the deliberations that happen in that grand jury room. They will not issue a true bill of indictment or a no bill of indictment based on love or affection or hatred for anyone. They're going to be open-minded. They're going to take whatever information they get and determine whether or not there's probable cause for that particular court that's going to hear that case to have jurisdiction and actually take it to trial. That's an excellent question. Thank you for asking that. Keep those questions coming. Let's get back to the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back. I'm here talking to Dayna Jones. One of the things I've talked to appellate attorneys about is, when you're in a jury trial, and you've tried cases before a jury, you have to think about doing things on the spot. It's a moment by moment thing. You're analyzing everything, right? Not just necessarily the law, but you're also trying to have a positive effect on the jury who's paying attention, because you want to influence them in the arguments and in your manner and everything about how you're handling that case. So looking back from an appellate perspective, reviewing just that cold record, you don't have the benefit of feeling what it's like to be under pressure and under the gun to come up with those types of strategies that go into having a successful defense in a jury trial.
There's not the theatrics on appeals like there are in jury trials. And so we can kind of analyze, word for word of what somebody said. It might have been a really quick moment in the court, but on paper, it really stands out because I can read the black and white of what they actually said. But yeah, we don't get the we don't get the tone of voice. We don't get the emotion that comes from I actually just wrote an article about this too.
Yeah.
About painting the picture in the record, because a lot of times I'll just read and I can't tell what's really going on. But if a defense attorney, and it's hard to think on your feet like that, can say things like, I see you're getting really emotional about this right now. Or we do see a lot of like, was the distance this far? But if you're saying like, was it 10 feet, and kind of painting those things into the record, it definitely helps a lot. But yeah, when we're reading the record, it is just black and white paper, and I'm not getting all of that kind of emotion and what really comes out when it happens live in court.
I'm really amazed sometimes when I'm in a jury trial and I'll hear a question asked and there's an objection, and the objection is very specific. And I'm thinking, no, the question sounded right, but I'm reviewing the court reporter's real time so I can read what the court reporter is writing at the same time that it's being said on the stand. And then I'll find one word inserted in that sentence that changes the whole question, the whole scope of that question.
Yeah.
And it's amazing to me how attorneys can hear and pick up those little tiny words and understand the change in what that sentence structure meant to make that effective objection.
Yeah. No, and being a trial lawyer, I've done it. It's hard to think on your feet. You're paying attention to a lot of things that are going on. You're listening to the witness, you're listening to the question, you're kind of, watching the jury to see their reactions to things going on. You've got a lot of going on. You've got your client next to you who might be passing you notes, trying to tell you things to ask or things that they're noticing as well. So it's definitely a lot of thinking on your feet, and it can be very stressful. On my end, I get to do it from the comfort of my chair at my desk. I get to read everything, and I get to research the law, and I can do it on my own time. If my brain's not working at that particular hour, I can come back to it and, put it down and come back to it a little bit later. So there's definitely a lot of stress to it, but it's not that high pressure in the moment like a trial lawyer has to do.
So the kind of work you do is good for people that are really a brain, in a sense, where they enjoy parsing out sentences, they enjoy reading, they enjoy writing, they enjoy being isolated sometimes in their job. I can imagine if you only did appeals, if you only did writs, you really wouldn't go to court very often.
Yeah, I don't come to the courthouse very often. I do miss it. I used to be here every morning running around. And sometimes I just really sit at my desk all day long on my own, maybe have a little interaction with my secretary. But aside from that, I'm just focused on, my computer screen and the transcripts that I'm reading and the law that I'm researching.
Let's say that you went through the trial, you got the transcript, you got everything that you need, you wrote your brief, you filed it. You mentioned then at some point that the other side, in this case, the state's attorney, will then file a brief in response to yours.
Yes.
What would happen then?
So I'll get their brief and I'll review it and see if there's anything that I feel like I need to respond to. If I feel like everything in my opening brief was already covered everything that they've already said, or that the state's saying in their brief, then I may not respond. But if there's something that I missed, like maybe a new case came out since I filed my brief and they're bringing that case up, then I will need to file a responsive brief, a reply brief, and address that particular case too.
How long does it take you to write these briefs?
If I sat down, so if you can imagine, because I sit down as I'm reading the transcript, I'm typing, and I will also be trying to issue spot. So I will be making notes to myself about, okay, this is a potential issue on this particular page. And I'll kind of make a note to myself for that as well. So it definitely takes a long time to do that. And then to go on the other side of it, and then you start, researching all the law and plugging it in there. It can take a full 40 to 80 hours, depending on how long the trial was and how many issues you actually come up with.
So in this case, you're in front of the fourth court here in San Antonio, or the case could be transferred, which has been happening a lot lately. Yeah, go to other jurisdictions. Wherever your case is, you know that you have that right of first appeal. So the briefs are done. The courts are looking at it now. How do you come to the decision as to whether or not you're going to have an oral argument?
So if I think that there's kind of a novel or unique issue that the court might want to hear about, I have to, in every brief, we have to say whether we're requesting oral argument or not. So if I think something's really interesting that the court will, want to talk about, I will request oral argument. If it's something that I think is very clear in the record and there's not going to be any need for oral argument, I won't request oral argument. So then The state also has the opportunity to request oral argument or not. And then we kind of wait around. Usually takes a few months, and then the court will let us know if they have granted us oral argument and here's your date and time that you need to be here to present, or if they're just going to be doing it on the briefs alone.
There are 7 justices on the Fourth Court of Appeals.
Yes.
I guess other courts of appeals in Texas may or may not have 7. They could have less.
They could have less. Yeah, I think there's some that have 5.
Mm-hmm. So in whatever particular court then, where a panel is assigned, generally it's the Chief Justice of that appellate court that makes those assignments.
That I don't know, but I think so. The panel that you're talking about is when we go to the appeal, we actually only get 3 out of those 7 judges. So the panel consists of 3 judges. They're randomly, or we don't know who they're going to be until they tell us, hey, your brief is now going to be heard, either oral argument or the brief alone is going to be heard by these 3 particular judges.
What's it like to go before the court and do oral argument?
I actually really love it. You get very prepared. I mean, you have a lot of case law. You know your brief frontwards and backwards. You only get 20 minutes to present. So if you have a lot of issues, sometimes the court gives you a little hint and they say, all right, Dayna, you filed 15 issues. We only are interested in these 3. And so you know you need to really prepare for those 3. So you have 20 minutes, you're standing at a podium, you've got 3 judges right in front of you, and you start talking, and they just start, whenever they want, they can fire questions at you, and you have to think on, that's when you have to think on your feet as an appellate lawyer and answer their questions. Then the state gets a chance to stand up and give their rebuttal, and then, their argument, and then we get a little bit more time at the end to do rebuttal.
So you could be making an argument, and you could present some fact scenario, and a judge can say, hold on a second. The way you're saying it, if that applies, then you follow that particular path. This extreme could apply as a result of us buying the argument.
Yeah.
They do those kind of things,
Yeah,
right?
exactly. So you have really no idea. I mean, you kind of try to anticipate what kind of questions they're going to be asking, like what would I would want to ask if this was the case, if I was the judge up there, but you really don't know what they're going to be asking. You don't know which way they're thinking. You kind of get an idea whether they're kind of going along with your arguments or not based on the questions that they're asking. But aside from that, yeah, you have to just anticipate what legal or factual questions they're going to fire at you.
I was reading not too long ago that Clarence Thomas on the U.S. Supreme Court had gone a significant number of years, without ever asking a single question during oral argument. And so I can imagine that in your mind, you probably want to know who's on that panel so you can say, this type of judge tends to ask a lot of questions, or these types of questions. What's that process look like for you?
So yeah, once we know who the panel is, if I don't know the judge personally or kind of professionally, I do go back and research some of their cases that they've written. I want to see if the cases that I've cited, if the judges that I'm in front of have made those opinions, because I want to be able to say, well, when you wrote this opinion on this legal issue, you said it this way, and if that's, especially if it's on my side. But yeah, you want to know what the judges, how they've ruled in the past. So I do a little research into some of the cases that they've ruled on before, and get prepared that way.
Let's say you've gone through that process. What happens then? I guess you wait for the court to come up with its opinion, and whether or not that opinion's published. What happens then?
Yeah, we after everything's done, they say, okay, our opinion will be forthcoming, and then we just sit around and wait. There's no deadlines for the courts to give us an opinion. Most appellate courts, especially the Fourth Court, their opinions come out on Wednesdays. So all of us appellate nerds in the community log into our computers at 9 a.m. on Wednesday mornings to see which cases they ruled on that particular day.
Because at 9 is when they come
they
out
issue them. Yeah. So the Court of Criminal Appeals comes out on Wednesdays at 9. Most of the appellate courts, a couple of them come out on Thursdays, but yeah, we look for those. You never know when your case is going to come out. They don't tell you. There's not like a phone call the day before saying, get ready for this opinion. There's nothing like that. You just learn as soon as it shows up on their website.
So let's say that the Fourth Court then agrees with you. What are some of the things that can happen if they say, all right, Ms. Jones, you did an excellent job. We agree with your argument.
So it depends on what the issue is. Let's say the issue that I raised is that the evidence was legally insufficient to support the conviction. That means that the state did not meet their burden of proof. They did not prove their case beyond a reasonable doubt. And the court, if they agree with me on that, it would get a judgment of acquittal. They would say, case over, not even going to remand it for a new trial. This person's innocent, or they can their case is overturned, they can't be retried, and they get to walk out and the state cannot retry them. Most likely, if I win, the state is probably going to take it up on appeal, and they have the opportunity to take it up to the Court of Criminal Appeals. Well, before that, they can ask the court to rehear the case. So you can file motions for rehearing. You can ask the same panel of 3 judges to rehear it, or you can ask for en banc reconsideration, which means you're asking the entire court, all 7 judges or however many judges, to hear the case. And after that, then you can go up to the Court of Criminal Appeals and say, I think this lower court got it wrong. That's what the state would be doing in our hypothetical, and ask the higher court to reverse what the lower court did.
I can imagine a finding of insufficient evidence and then an acquittal is not very common.
It's not very common. No, it's not.
How often have you seen that?
Really not. It's very rare. I would say maybe I will hear about 1, maybe 2 a year, but not that often at all. In the state of Texas, yes. Throughout the entire state, yes.
So then, generally speaking, if you get a reversal on a case, it means that they can either reverse and render, or they can reverse and
remand for a new trial.
How does that work?
If it's remanded for a new trial and it comes back down to the trial court, after a certain period of time, a mandate will issue, which a mandate is basically a directive to the lower court saying, hey, we're done with what we're doing in the appellate court. It's now back in your court, and your court would then put it back on the trial docket.
Right. Which means the case starts all over again.
Yes.
And I have seen situations, right? Sometimes people think, all right, you got a reversal on your case. Let's say somebody got a sentence of 10 years. Reversal, go back to the trial court. It's possible that case will be retried, and in that trial, that person will then get sentenced to whatever that range of punishment is, or somebody gets a very significantly larger verdict as a sentence than what they had before the appeal.
That is always the risk, and that is definitely something I have a lengthy conversation with my clients who did not get on the higher end. If somebody comes to hire me, and actually this just happened this morning, they're facing 20 years. They only got 5 years from the jury and they want to appeal. The conversation has to be, if you appeal and we win, you are now back to facing 20 years again. This is something I can't make these decisions for you. So that's something that goes into before we even start the appellate process, for sure.
So it doesn't automatically mean that their sentence will be less or that their case will be dismissed.
Yeah, nope, it doesn't.
And the majority of opinions that go in favor of the defense generally remand back for a new trial.
Yes, generally, yes. And there's also, so if we had some error, let's say the trial part, the guilt, innocence part didn't have any issues, but the sentencing part, let's say there was something wrong with the sentencing, they could actually remand just for new punishment alone as well.
Which would really mean the whole new trial.
Really, because you have to, if you're going to go back to the jury again, you have to pick a whole new jury, and really the state needs to put on all the evidence again so that this new jury who's going to consider sentence hears all the facts again.
Right, because everything generally in a guilt innocence phase of trial is something that the jury can consider at the punishment.
Yes, exactly.
So then let's go the other way. Let's say that you finished your briefs, you went before the courts of appeal, you had your oral arguments, the court says the lower court is affirmed, or let me say this differently. The court says the lower trial court's judgment or sentence is affirmed, then you or the other side, the state, gets to appeal. You mentioned the Court of Criminal Appeals. Do y'all get an opportunity to do some different briefs? How does that work?
So at that point, you're really looking at, did the appellate court get the law wrong? Or, I mean, sometimes there can be factual issues and stuff like that, but the higher court is really looking at, did this lower court get the opinion wrong? And is this something we need to step in and get it right on, or review? So that's another consideration of whether you take a case up to the Court of Criminal Appeals or not.
And we talked about how in the intermediate courts, that's a mandatory, right? They have to take that case. They have to make some decision on it, but it's discretionary with the Court of Criminal Appeals. In other words, they don't have to accept that appeal to them at the onset.
Right. So yes, the intermediate courts have to hear a case, an appeal that's before them, but what we actually file to the Court of Criminal Appeals is called a petition for discretionary review. So the name, like you said, it tells you right there, it's discretionary. The courts can hear it if they want. They don't have to hear it.
Right. Well, Dayna, I've really enjoyed this conversation with you.
I have too. Thank you so much for having me. This has been great.
I know that there's not a lot of people that do post-conviction work in Bexar County, really in any jurisdiction. And so I know you're busy. I really appreciate you coming on, sharing your experiences with us. Are there any last words that you would have to our audience?
If you have any loved ones that have been wrongfully convicted, that you believe has been wrongfully convicted, you can reach out to my office. I would love to chat with you about it. My website is jonesdefense.com. My law firm is Jones and De La Garza. And I hope that, the pendulum, in my view, has kind of been swinging, that there's a lot of people that are being open-minded to wrongful convictions. And I hope that continues. And I think that's through a lot of, the communities being aware that this actually happens. What are the causes of wrongful convictions? And I think when we identify what the causes are, we can prevent them from even happening.
That's right. One of the things that we were talking about before we started recording is that when I was in law school back in the 90s, people really wanted to work as prosecutors. And it seems like over the course of time, the pendulum has swung, as it always does in the law, goes back and forth on different issues and topics. But it seems like there's really a lot of interest in issues like the Innocence Project and those that get wrongfully convicted. So what you're doing is important work, Dayna.
Well, thank you. I appreciate it.
You're very welcome, and thank you for coming in. We've reached the end of this episode. Thanks so much for listening. Don't forget to subscribe to our website and keep sending in those questions. We really enjoy answering them. We'll be back in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.